Good afternoon and welcome to the third Taylor Wessing Contentious Trusts Estates webinar, during which we will discuss the concept of insolvent trusts and how the law is developing in this area, with reference to the Jersey case of Z Trust, in which we have been acting for the former trustee. By way of introduction, my name is Kate Silverman and I'm a Senior Associate in the Contentious Trust and Estate team here at Taylor Wessing, and my co-presenter today is Amelia Fishgors, another associate in the team. As usual, you can put any questions that you may have during the course of the webinar to us by simply typing them out in the panel below the slides on your screen, and we will try and deal with as many questions as possible at the end of the talk. So I'll hand over to Amelia to kick us off.
So the concept of an insolvent trust. A trust is not a discrete legal entity and as such cannot technically be insolvent. Any liabilities of a trust are personal liabilities of the trustees rather than the trust. It is therefore against the trustees that any claims can be brought for liabilities. However, there are two scenarios in which a trust can be said to be insolvent in a non-technical sense. The first is where trustees are unable to meet their liabilities and they are made bankrupt or wound up in the case of corporate trustees. In certain circumstances, the relevant creditors may have recourse to the assets of the trust, and where these assets are insufficient to meet the liabilities, the trust may be described as insolvent. The second is where the liability of the trustees is limited to the extent of the trust assets, but, as before, the trust assets are insufficient to meet the liabilities. The Royal Court of Jersey in the representation of the Z Trust has confirmed that the cash flow test, i.e. whether a debtor is able to meet its debts as they fall due, is the correct test to apply in order to ascertain non-technical insolvency of a trust. Neither England or Wales nor any of the offshore jurisdictions currently have in place legislation relating to insolvent trusts. A consultation response and policy paper has just been released in Jersey in relation to the Trust Jersey Law Act 1984, and it has been decided that no amendments to the Act should be made to try to address the issue of insolvent trusts. However, Emma Jordan, head of the Contentious Trusts team at Taylor Wessing, has recently been appointed as a member of a Jersey legislative working group consulting on a possible statutory regime in relation to insolvent trusts. So watch this space. We are not aware that any such legislative changes are being considered in any other jurisdiction.
Thanks, Amelia. So I'm now going to give you an overview of the Z Trust case, which is presently before the Royal Court in Jersey, and we'll highlight a number of interesting points for trustees to be mindful of when dealing with insolvent trusts. So the Z Trust case. Now, to our knowledge, this is the first time a case dealing with insolvent trusts has come before the Jersey courts, or in fact has come before any court in any jurisdiction. Emma Jordan is representing the former trustee of the relevant trust in her capacity as a Jersey advocate on this matter, with associate support from myself and Amelia. Now, before we delve into the issues which have come before the court in this matter, I'm just going to briefly run through the factual background. So, the settlor, Madam Newry, originally settled 8 trusts, which were all administered by the same trustee, and that was our client, Equity Trusts Jersey Limited, who, for the purposes of this talk, I'll just refer to as Equity. And the trusts are known as the Ironside Trusts, and they're numbered 1 through to 8. Now, the settlor was a beneficiary of all but one of the trusts, along with other members of her family, including her son, Simon Halaby. The trusts are all subject to the proper law of Jersey. The trust has seen a number of changes in trustees over recent years. Our client, Equity, retired as trustee of all 8 trusts between 2006 and 2007, with Volaw becoming trustee of Ironside 1 and 2, and Barclays becoming trustee of the remaining 6 trusts. Volaw and Barclays have since been replaced by Rawlinson and Hunter, so they are now the trustee of all 8 trusts. And that recent change in trusteeship has given rise to a conflict of interest argument, which I will come on to shortly. Now, the Halaby family made their fortune in property, with the trust asset pool including multiple very expensive and large properties all over London and further afield. However, the properties were oversecured, and following the credit crunch in 2008, the properties were held in negative equity, and the family's wealth, which had been settled into trusts, therefore began to unravel quite quickly. Now, as you can see from the slide, the liabilities of both INSR2 and INSR3 outweigh their respective assets, with significant debts owed to both connected and unconnected creditors. Now, the most problematic issue from an administration perspective is the outstanding interest-bearing loan, which was paid by INSR2 to INSR3 of approximately £186 million. INSR2 have actually now written down that loan in its accounts to only £6 million to reflect its likely recovery from INSR3. Now, given the fact that its liabilities greatly outweigh its assets, the Royal Court declared INSR2 insolvent on both a balance sheet and a cash flow basis. INSR3 has similarly been declared insolvent on a balance sheet basis. So we therefore currently have a situation where we've got two insolvent trusts being administered by the same trustee. One trust owes a significant sum to the other trust by way of a loan, and both trusts have outstanding connected liabilities to the settlor and other beneficiaries, and they've outstanding unconnected liabilities to third parties, including the former trustee. So with the background established, let's now have a look at how the court has ordered these trusts to be administered. So once both INSR2 and INSR3 have been declared insolvent by the Royal Court, the court needed to determine what type of insolvency regime should be put into place for each trust, and the Royal Court considered this issue back in October 2015. Now, there were three regimes for the court to consider. The first regime was put forward by the trust's respective trustees at that time, and that was Zola and Barclays. Now, this involved the appointment of an insolvency practitioner to assess the creditor's claims. In the alternative, the trustees actually offered that they would assess the claims to avoid the expense of engaging an insolvency practitioner. And this approach was based on a precedent from an Insolvent Estates case. Now, when considering this proposal, the court identified a fundamental difference between an insolvent estate and an insolvent trust. With an estate, an insolvency practitioner will assess the claims due by the estate to third parties. But with a trust, an insolvency practitioner would be assessing the claims due by the trustee, not the trust, to third parties. Now, as Amelia says, a trust does not have its own legal personality, so any claims made in relation to a trust are claims made through the trustee. A creditor's rights are subrogated to the trustee's rights under their indemnity. So essentially, the creditor steps into the trustee's shoes. On this basis, the court considered that there is an inherent conflict in a trustee undertaking the process of examining, admitting, or rejecting claims against itself. However, the court also made the point that any claims by a creditor would not result in any personal liability by the trustee by virtue of the fact that the trustee has an indemnity. So actually, the conflict has limited impact in reality. Now, the second proposal was put forward by our client Equity, and we suggested that the court should directly appoint an insolvency practitioner to act as an officer of the court and wind up the trust, which would include realising the trust assets. This approach would reduce the existing trustee to that of a bare trustee. Equity also proposed that there should be different insolvency practitioners for each trust, and the insolvency practitioner should conduct an investigation into the affairs of the trust to determine any potential breaches of trust, reporting their findings back to the court on a confidential basis. Now, Rawlinson and Hunter, who at this stage were the proposed new trustee, and the settlor, resisted this proposal, primarily because they argued it would incur substantial fees which would reduce the asset pool further. And they proposed an alternative third approach. So Rawlinson and Hunter offered to take over as trustee of both INSR2 and 3 trusts on the basis that it would not charge for its fees and expenses against either trust until further order of the court. And I should just explain that it had agreed for its fees to be paid by a third party who wasn't a debtor or creditor of the trust. It also offered to take a direct novation of all of the connected creditor claims and those of Equity, which released Barclays and Volor from the liabilities incurred by them during their time as trustee. Rawlinson and Hunter also offered an undertaking to the court that no payments would be made out of INSR3 other than for the maintenance and upkeep of the trust assets without court approval. And it also undertook not to take any steps to prejudice INSR2's recovery of the loan and to administer INSR2 under the supervision of the court. So, which regime did the court favour? Well, the Royal Court broadly endorsed the approach proposed by Rawlinson and Hunter. It agreed to Rawlinson and Hunter's appointment as trustee of both trusts under the supervision of the court and accepted the proposed undertakings offered by Rawlinson and Hunter. The court also gave certain directions as to what should be done to clarify the status of certain third-party claims in relation to Irons R3. As a result, Rawlinson and Hunter were appointed to administer both trusts under court supervision. And when reaching its decision on which regime to apply, the Royal Court made clear that the court should be very flexible in its approach when dealing with an insolvent trust situation, having regard to the best interests of the creditors as a body and not the beneficiaries. Now, on this point, the court in fact held that the trustees will be committing a fraud on the power if they do not exercise their powers in the interest of the creditors once insolvency has been declared. In this case, after the Royal Court had declared the trust as insolvent, but prior to determining the insolvency regime to be applied, the settlor had actually taken it upon herself to appoint a new trustee. The settlor had the power to appoint a trustee under the trustee and had duly executed the necessary deed of appointment. But at that point, our client, Equity, objected to the appointment, and we argued that where a trust had been found to be insolvent, the fiduciary obligations previously owed to beneficiaries were now owed to creditors, and accordingly the settlor's appointment was not in the creditor's best interest, and it amounted to a fraud on the power. That argument was resisted by the other parties, but in reaching its conclusion on the matter, the court found some guidance in the approach of company law, and it concluded that where a trust becomes insolvent, it should be administered on the basis that it's the creditors rather than the beneficiaries who are the persons with the economic interest in the trust. So the court therefore concluded that the settlor's appointment in this case should be set aside. The court did, however, make clear that it was the creditors as a class for whom the fiduciary duties were owed, rather than any one creditor or even a majority of creditors. So trustees need to be very mindful at this point as failure to exercise their powers in the interests of the creditors as a whole, once a trust is considered to be insolvent, may lead to breach of trust claim against them by the creditors. And when considering the appropriate insolvency regime, the court also held that any insolvency regime should be conducted under supervision of the court, which is perhaps understandable given its inherent jurisdiction to supervise the administration of trust in times of difficulty. Finally, the court also stressed the need for the administration of trusts to be carried out as cost-effectively as possible when they're insolvent, and the importance of the trustee maintaining the value of the assets of the trust as much as possible. Right, I'm now going to move on and look into more detail at a couple of particular issues which have arisen in this case. So firstly, one of the major points of contention for our client in particular in this case is the existence of a clear conflict of interest where there's one trustee administering both insolvent trusts. So just to recap, there's two levels of conflict here. Firstly, as I've already discussed, a trustee of an insolvent trust is placed in a position of conflict when it's required to determine a creditor's claim. And the reason being, a trust itself has no legal personality, so any claim by a creditor is actually a claim against the trustee itself, and the creditor will be subrogated to the trustee's right of indemnity from the trust assets. The trustee is therefore assessing claims against itself, essentially. And the more claims it allows in the insolvency, the less likely the trustee is to recover their own claim in full. But this conflict is broadly managed by the fact that the court is supervising the trustee, and therefore any disgruntled creditor could refer the matter to the court for their assessment. The second conflict, however, is a more fundamental one. On the facts of this case, the solvency of Irons R3 is ultimately dependent on whether the trustee of Irons R2 calls in its loan. If it calls the loan in from Irons R3, this would obviously be detrimental to Irons R3's creditors. But if it does not call in the loan, Irons R2's creditors suffer because Irons R2's main asset is not being crystallised. Now at present, this conflict is being managed by the Royal Court supervising matters, but effectively there remains an impasse. Now it's hoped that once all creditor claims in both trusts have been determined, and the priority of those claims, which is an issue I'll come on to shortly, have also been determined, Rawlinson and Hunter will then be in a position to put forward a practical proposal which addresses all claims having pulled the two trust assets together. It seems to us that issues of conflict will always arise in some form or another when the trustee of an insolvent trust is required to manage the insolvency regime, and we question whether requiring the court to supervise this process is in fact the most cost-effective and efficient approach. I mean, to date in this case, various matters have been referred back to the court as there's no truly independent party conducting the winding up of the trust. And the effect of that has been delay and significant legal costs have been incurred. So now just moving on to the issue of indemnity. The role of a trustee's indemnity is also an important issue in the case of insolvent trust. As you're no doubt aware, a current trustee may have a contractual indemnity by virtue of the terms of the relevant trust deed, whilst a former trustee may have a contractual indemnity set out within their deed of retirement. In addition, depending on the jurisdiction, either trustee may be able to rely upon the wording of the relevant statute, which may state that a trustee is to be protected by an indemnity. Now, in our case, the client and in fact two of their directors were involved in litigation as a direct result of its role as trustee to Irons R2, and that litigation caused equity a serious financial hit. It had to make a settlement payment to the claimant in the proceedings and incurred significant legal costs in trying to defend the claim. Now, these are all costs which would normally be recovered by the client's indemnity, provided those costs would have been recovered when equity was trustee. However, the issue which has come to the fore in this case is how much protection does it actually offer if the trust is insolvent? An indemnity will only give a former trustee protection up to the value of the assets in the hands of the current trustee at the time the former trustee makes any claim. But with an insolvent trust, the assets are likely to be insufficient to satisfy a former trustee's liabilities under their indemnity. And this point was made in this case, and the court confirmed that a former trustee holds an equitable lien over trust assets in relation to payment of liabilities incurred from their trusteeship. Commissioner Clyde Smith applied the authority of Investec Trust Guernsey Limited versus Glenalla Properties Limited and others, which is a 2014 case which was decided under Jersey law. And Commissioner Clyde Smith expressed the view that the original trustee does have an equitable right under Jersey law in respect of its trustee liabilities and is therefore entitled to ensure that no steps are taken to destroy, diminish or jeopardise that right. And this mirrors the position under English law. So in effect, this equitable lien gives the former trustee a proprietary right to the assets in the trust and therefore does not limit it to the assets in the hands of the existing trustee at the date it seeks to claim under its indemnity. However, unfortunately, the court did not go into any further detail on the precise nature of this equitable right, or indeed the priority afforded to it, save to say that it took priority over beneficiaries' claims to the trust fund. So consequently, the Royal Court has confirmed the existence of this right, but at present, there is uncertainty as to how this will apply in practice. Now that leads us on to the final issue which I want to discuss, and that is the issue of the priority of claims. Now, the court has acknowledged that a former trustee has an equitable lien, which gives it priority to the trust assets ahead of the beneficiaries. But how is a former trustee's indemnity to be dealt with vis-à-vis the current trustee's indemnity? Does a former trustee have any form of priority over the existing trustee's indemnity? Now, the usual insolvency position when dealing with companies is the pari passu approach, meaning that all creditor claims will rank equally. Now, the obvious downside to this approach from a former trustee's perspective is that the pool of remaining assets will be split equally between all the creditors, regardless of how or when their claim arose. And the effect of that will of course, be to reduce the pool of assets, and so a former trustee will not recover their full liability. In fact, they may only recover a fraction of their debt. Now, the possible alternative approach would be for the claims to rank first in time. Now, by this, I mean that the creditor with the oldest right to make a claim has their claim considered and paid out first. And this would most likely see former trustees move up to the front of the queue. Now, just to be clear on this, this is not the oldest outstanding invoice, but the creditor whose right to make a claim first arose in time. The basis for this argument is that the court acknowledged that a former trustee holds an equitable lien over the assets in the trust, which gives that former trustee a proprietary right to those assets over and above the beneficiaries. But the question for the court is whether it also gives them rights over and above any other creditor. Now, this priority question has not yet been considered by the court, but it's likely to be the next issue for the Royal Court to determine in this case. There's certainly a policy argument for Jersey trustees to be able to step into the shoes of the current trustee of an insolvent trust and have their claim addressed ahead of other creditors, because otherwise the former trustee's indemnity would essentially be worthless in an insolvency situation. In such a scenario, a trustee would need to retain the entirety of the trust fund pending limitation periods concluding, which could be potentially 6 to 10 years, or they would need to draft something into the DORA to give them priority in the event of an insolvency. An alternative answer would be for trustees to rely on their insurance, but to look to insurance is not really a complete answer because corporate trustees will often still have to pay some of the liability and the costs even if their insurers stand behind them. Moreover, it will probably see a significant increase in insurance premiums for trustees. At the moment in Jersey, from a regulatory perspective, trustees are required to have insurance of, I think, £5 million per claim, but not more than 10 million. And as demonstrated in our case, that level of insurance is likely to be insufficient for a former trustee in an insolvent trust situation. Now, one smaller priority decision which the Law Court has already addressed relates to the trustee's costs in administering the trust once it's declared insolvent. But the Court held that the current trustee does gain priority over other debts for these costs. And this can be contrasted with the position of insolvent estates in England, where the costs of an administrator are not given any such priority. The Court's rationale for taking this approach is to encourage trustees to take on the role of administrator under court supervision, rather than simply sitting on their hands. As I said, we expect the priority argument to be heard at some point this year, and we'll certainly provide an update following the outcome of that hearing. So I'll just now hand back to Amelia to conclude the presentation.
So given what Kate has discussed, we thought it might be useful to give a few high-level practical tips for trustees in order to try to avoid an insolvent trust situation. Firstly, trustees should ensure that there is a diversification of the investment of trust assets and that qualified and expert investment managers are used. Very often, beneficiaries who are not necessarily experts seek to have trustees follow their advice as to the management of trust assets. Trustees should be wary of this, both from a breach of trust point of view and an insolvency perspective. Secondly, where loan requests are made by beneficiaries or third parties, trustees should be careful to ensure that there are sufficient assets in the trust fund to make such a loan and to meet any future liabilities with the reduced liquidity of the trust fund as a result of the monies lent. Thirdly, the trustees should ensure that they know the value of the assets within the trust. With something like art, this can be difficult, which is why appropriate experts should be used and regular valuations should be conducted. So if a trust is insolvent, what should you do if you are either a current or former trustee of the trust? So turning to current trustees first, current trustees should call in and secure trust assets, ensure that they do not reduce the trust assets further. Once trust is insolvent, trustees should be aware that they now owe their duty to the creditors of the trust as a class and not the beneficiaries, as Kate previously mentioned. To continue to act in the interest of the beneficiaries rather than the creditors may result in a breach of the duty and a fraud on a trust power. Trustees should seek the court's directions as to how to administer the trust and to provide supervision. The trust should be administered cost efficiently and a court order should be sought as to any payments to be made out of the trust, and the trustees should ensure that their own fees and expenses are given priority. So former trustees, as Kate has previously highlighted, the insolvency of a trust has potential ramifications for both the current trustees and the former trustees. So what should former trustees do once they learn that a trust they previously administered is insolvent? A former trustee should request that the current trustee uses an independent to assess any claims against the trust, and as part of this should encourage the current trustee to have the trust administered under the supervision of the court. The former trustee should also try to ensure that nothing is done by the current trustee to further dissipate trust assets, and that the trustees should call in and look to secure the trust assets. That brings us to the end of the substantive section of our presentation, which we hope you found useful, but we do have some time to deal with a few of the questions that we have received. The first question, which we'll deal with, is as follows. Someone has asked, some jurisdictions allow a former trustee to take out security over trust assets to cover their liabilities. Does this not provide sufficient protection? Kate, do you want to deal with this one?
Yeah. I think this is a very interesting point. The provisions which entitle a former trustee to security are certainly a starting point, but it's very difficult to know the value of future liabilities at the time a trustee retires. The limitation period, I think, as I mentioned, for claims could be between 6 and 10 years, depending on the relevant jurisdiction. So a retiring trustee won't, therefore, at the point of their retirement, won't have the visibility and know what a suitable security value should be. And I think really the security provisions were really only intended to cover a trustee's outstanding fees, rather than sort of large liabilities such as those faced by our clients in the Z-Trust case. I think it would be very hard to agree a large security sum with any incoming trustee on the point of retirement. And I think ultimately, if the matter was referred to the court's direction, I can't see a court particularly endorsing that approach. So I hope that addresses the question put to us. We've got, I think, time for a second question. So someone else has actually also focused on how a retiring trustee might protect themselves, and has asked the following question. So they've said, could a former trustee obtain protection by seeking some form of undertaking from the new trustee on the transfer of the trusteeship, that the new trustee will not allow the value of the trust fund to drop below a particular amount? So essentially, I think the question is whether the incoming trustee can guarantee the outgoing trustee that the assets won't drop below a certain value. And I think this is an interesting suggestion. Certainly, consideration needs to be given by a former trustee on the transfer of the trusteeship as to how its possible future liabilities may be protected. But I don't think this particular approach would unfortunately work, because it's likely to be seen as an invalid fetter on the new trustee's powers and their discretion as to how they administer the trust. I mean, it may be that a former trustee could seek some form of personal indemnity from the new trustee, but I think that would very much depend on the bargaining position of the respective parties at the time of the transfer of the trusteeship. I mean, the key issue, I think, to bear in mind is that we need to ensure the priority for the former trustee and the priority of their indemnity. So I think one sort of practical approach would be to draft something into the DORA, into the deed of retirement, which gives the outgoing trustee's indemnity priority over the incoming trustee's indemnity. I mean, I'm not sure whether such a clause would be enforceable, but in our experience to date, we found that it is at least acceptable in DORA negotiations, and it certainly would give you some form of starting point, some form of argument to take forward. So I hope that addresses that point. Unfortunately, I think that's probably all we've got time for now this afternoon. But I hope today's webinar has been helpful. We will follow up on those questions which we've not had a chance to answer by email, and we'll also send out slides from this presentation together with a recording of the webinar to all the attendees so that you can share it with your colleagues if you wish to. So many thanks for your time.